Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. We are live and on the record.
So I'm working remotely, and if you hear some noise in the background, I think you might be hearing my dog barking, and I apologize. There's little I can do about that at this moment, so hopefully that won't interfere with the hearing. For the record, this is the matter of Henry versus Alencar, docket number 21J420. It's an appeal by Ms. Alencar of an order of the lower court allowing an appeal bond in the amount of $1,000 and use and occupancy in the amount of, I believe, $800. And it's your appeal, Ms. Alencar. So without getting into new territory of any negotiations, I'll hear you on the merits of the order by the lower court judge. Go right ahead, Ms. Alencar.
I'm sorry, you must have skipped out. I didn't hear anything.
Oh, all right. So, Ms. Alencar, this is the matter of an appeal of the appeal bond of $1,000 and the use and occupancy of $800 that was ordered by Judge Theophilus of the Housing Court. And it's your appeal as to the merits of why that should not stay in place. So I will hear you.
Okay, yeah, well, I should not have to pay the appeal bond because I am indigent. And the judge in the housing court tried to rule on matters that she had no, I guess, authority to rule on. She, you know, the land court needs to rule on my case, and she just thinks that this, I'm sorry, I'm trying to get the words out. She thinks my case is frivolous, which she really didn't have, I don't think has the authority to say that it's a frivolous case because it's in land court, and land court does not say it's frivolous. And based on the whole housing court case is, you know, whether the judgment should be there or not really depends on the land court case. Also, I should not have to pay $800 rent because I moved in here under the agreement that I would not be paying any rent or anything. And they tried to argue in the housing court that my situation is similar to a post foreclosure, which it is not, because in a post foreclosure, that owner would have been paying, in essence, a mortgage, which is the same as rent, which the agreement was I would not have to pay anything.
Well, the judge in the lower court found that you had not established indigency, as I read her order.
Yeah, and I did. I have Mass Health.
And your position is Mass Health alone establishes indigency?
That's what I was told. They give you the paper for indigency. They make you check off all the boxes. They have you all the boxes. And I have checked online, and it says, yeah, because indigent is low income, which would affect the ability to care for your children and stuff. And putting out that money would greatly affect my children. I am indigent. I am low income, receive Mass Health, you know, can receive other low income benefits. I should not have to put an appeal bond in order to fight my case. Based on that.
The appeal bond was one issue, and the use and occupancy is a separate issue.
Yes, I know that, but I was told that it was all together because the appeal bond was in here, and that
no, it's all together, but it's all together.
Okay. Yeah, so I shouldn't have to pay, like I said, I shouldn't have to pay the appeal bond because I am indigent, and I should not have to pay use and occupancy because the agreement between Mr. Henry and I, when I moved in here, was that I mean, there's just a larger portion of this, you know, which has to do with sales of real estate, transfers of money and everything, but there was never any agreement for rent. They were trying to argue a post foreclosure, which in a post foreclosure, that would be someone that was paying rent before. I was not paying rent before. I should not be made to pay rent now. Mr. Henry is losing no money on this house. If anything, while this court case has been pending, you know, the house has appreciated in value. He is ultimately trying to sell this house, which I did try to ask him to buy, and he refuses to sell it to me, but will sell it to anybody else.
Is there anything further
Mr.
you
Henry
want
is
to? Go ahead.
Mr. Henry is my father, and what he has done to us is totally wrong. You know, and we're in negotiations currently trying to settle this matter so that I can vacate this house, because neither me nor my children want to be here any longer because of the hell that he has put us through.
Is there
And
another
denying
act? Is there another action pending in the land court?
There is an action pending in the land court, because we had agreed upon, I gave him money for the agreed purchase of this house. And
No. I understand what the allegations are, but you filed an action in the land court, or did he file yet?
I filed an action in the land court prior to now there was, you know, COVID and everything, you know, made everything extremely difficult. I did the best I could. I filed an action in the land court prior to the hearing that was in the housing court, and the housing court would not, the housing court wanted to evict me anyways, and said they didn't care what the land court had to say.
All right. Is there anything further you want to add?
At this point, no. I mean, I'm indigent. I should not have to pay the appeal bond. I meet the criteria for the indigency. My claims are not frivolous. And like I said, I should not have to pay him. I should not have to pay him rent. Especially because when he comes, he has made this house hell. I mean, currently, I believe he has moved to Florida, so because we have not seen him in several weeks. But he will come into this house. I have no idea if other people have keys to this house. I don't even have keys to, you know, certain parts of the house. He has put restraining orders on me. He does everything he can. You know, he comes up when he does come into this house. Him and other people will come up into my living area, which I have the living area on the top floor. He was supposed to have the living area on the bottom floor. He has vacated the premises, but he's the owner of this house. He will call the police to tell the police, have them tell me he can come up into this house. He can do whatever he wants. He will come up into here. He goes through our things, through our bedrooms. I mean, it's a total I'm living in a hell. I have no legal right to any privacy.
I understand. I understand your situation as you describe it.
Yes.
You're going a little beyond the scope of what I have to hear today. I understand that there is an ongoing dispute. It's
right.
I'm reviewing and once I hear from you, I'll hear from Attorney Sylvia, but this is your only opportunity to be heard on the legal arguments regarding the appeal bond and the use and occupancy. So I understand the situation.
I'm telling you that I am indigent and that I should not have to pay rent because I am not a post. They're trying to compare me to a post foreclosure. In a post foreclosure, that person was prior paying a rent or a mortgage. Then they had an agreement to pay that mortgage. I am not a post foreclosure because we had no agreement whatsoever. There was never any agreement for rent. And also, Mr. Henry will come up for rent. You are to pay a rent or a use and occupancy or a mortgage. You get a level of privacy and a level of quiet enjoyment, which me and my children do not receive here. I think that's it.
Okay. So I'm going to hear from Mr. Sylvia, and then the hearing will be over. You understand that?
Yep.
Okay. Attorney Sylvia?
Thank you, Your Honor. Well, our argument today is that the facts here do not warrant any change in this bond decision by Judge Theophilus. It was a reasonable decision after a hearing where licensed real estate broker Eileen Prisco testified. She's a licensed real estate broker in the area where the house is and has experiences with rentals in the area. She testified that the fair market value of this particular property is anywhere between $2,000 and $2,500 per month. As Ms. Alencar addresses my client's ability to access the premises, that was taken into consideration when Judge Theophilus made her reasonable order on use and occupancy to reduce it all the way down to $800 from that figure that I'm citing, where the real estate agent was saying $2,000 and $2,500. So Ms. Alencar is already receiving the benefit of a reduced use and occupancy to be able to stay there. It's my understanding that she has a job, she has regular employment, and has not presented before the court either today or in any prior hearing that she's legitimately indigent and incapable of posting a $1,000 bond, which is not an egregious amount here. And on a technical point, as I've reviewed the record, it appears that the bond decision came out and we were notified on 7/23/21. Ms. Alencar filed her an application to review the bond decision on 7. The decision came out on 7/16. Ms. Alencar filed her application to review it on 7/23. This is 7 days later. This was well beyond the appeals period that preceded the judgment and the judge's decision for possession. So under 239 section 5E, she's afforded a 6-day period to appeal the bond decision. And I'd submit that if you look at the record that she did not file a timely appeal here, she was 1 day late. So I'm arguing that she's technically barred to bring this appeal. And if the court does not want to consider that, once again, I believe the Judge Theophilus made an entirely reasonable decision, taking into consideration the merits of Ms. Alencar's appeal, because there are two distinct issues as to whether Ms. Alencar can reside on the property following this trial, where she did not put forth enough evidence to satisfy the judge that she was an owner, and the separate issue of her ownership status in land court. These are two distinct issues as to whether she can stay there now and litigate her appeal of the housing court decision, and whether she can make a legitimate claim in land court, which there is a pending motion for summary judgment in place right now. So, Your Honor, while this appeal is in place, we're asking that this bond order remain in place and that she be ordered to comply with it.
This is a little beyond the scope, but in a way it goes to the non-frivolous defense aspect. Was there any new evidence presented by way of written documents evidencing ownership in the home in the land court?
No.
I did present other documents, and I will be presenting documents in the housing court. Those documents are not presented because the housing court specifically said to me, we cannot determine who owns the house. We cannot determine this ownership dispute.
There was no new evidence.
We can only
All right, Ms. Alencar.
make a decision based on what is on the title. So I did not present all the evidence I have in housing court because that's
All right,
He
but
made
my
the
question,
same exact
on that.
argument.
my question to Attorney Sylvia was whether there was new evidence presented in the land court as of yet.
No,
Do you agree with that, Ms. Alencar?
I think I did present other evidence.
All right.
But I know, I really cannot be sure, but there is other evidence to be presented in land court that was not presented in housing court, based on the facts based on the cases. One was an eviction, this is the ownership case.
I understand.
Okay.
Anything further, Mr. Sylvia?
no, Your Honor.
All right, that'll end this hearing. I will review the documents one more time. I'll issue my decision as soon as possible. Thank you very much.
Thank you.
Thank you.
We are live and on the record.
All right, this is the matter of Tyrone Walker versus Juliane Pierre. It's a single justice matter, docket number 2021 J434. And I'll hear from Ms. McKinstry.
Thank you, Your Honor. So I represent the defendant, Juliane Pierre, who is the mother of the plaintiff's children. The plaintiff actually purchased the property from Ms. Pierre's mother for the benefit of these children. And she's now—
Objection. Not relevant, not
No,
part of this hearing.
This is an argument, so I'll let her be heard. I'll sort out the relevancy of
Thank you.
the issues. Go ahead, Ms. McKinstry.
Thank you. So Ms. Pierre is appealing the Eastern Housing Court's judgment for the plaintiff in the present summary process case, and therefore she's seeking review of the Eastern Housing Court's denial of her appeal bond waiver. She's seeking this review pursuant to General Laws, Chapter 239, Section 5, which states that the single justice review shall be conducted as if initially deciding the matter. So the Housing Court heard Ms. Pierre's motion to waive the appeal bond on July 28th, 2021, and denied the motion that same day on the grounds that while Ms. Pierre is indigent, she lacked a non-frivolous defense as required by Chapter 239, Section 5. However, Ms. Pierre does in fact have a non-frivolous defense, specifically that she was entitled to a 90-day notice to quit. The standard of non-frivolousness is an incredibly low standard to meet. The Massachusetts Appeals Court stated in Tamber v. DeRocher, citing a Supreme Judicial Court case called Pierce v. Commonwealth, that frivolousness goes beyond simply lacking merit. It requires that the defense have not a prayer of a chance of success. The appeals court further clarified that a defense is frivolous if it is unsupported by any evidence at all. Accordingly, if there is some evidence to support a defense, that defense is non-frivolous for the purposes of an appeal bond waiver, regardless of how the argument would fare on the merits. The Housing Court didn't cite any of this language to support its finding that there is no non-frivolous defense, nor did it state its findings in terms of the relevant case law at all. But the fact is, Ms. Pierre has ample evidence, both factual and legal, to support her stated defense. The parties in this case had an agreement that Mr. Walker would pay the mortgage on the property, whereas Ms. Pierre would pay the utilities. But the parties never had any—
Didn't the lower court judge find that the payment of the utilities was the equivalent of a rental payment? And I believe you even cited Ducker versus Ducker to support your proposition, but Ducker versus Ducker seems to suggest such a payment is the equivalent of a rent. The judge said it was a 30 or monthly payment, so that would allow for the 30-day notice, according to the lower court judge. And so based on those findings, why isn't it non-frivolous?
That's a good question. So in Ducker v. Ducker, sorry?
Why is it non-frivolous, I should have said.
Yes, of course. So in Ducker v. Ducker, the nature of utilities payments is discussed in two different ways. So for the purposes of determining whether there was a tenancy at will, Ducker v. Ducker clarifies that any type of consideration can suffice for that matter. So in that sense, it compares utilities payments to rent to say that, okay, these utilities payments are sufficient to establish a tenancy at will. But then Ducker then came out to say that there was no rent that was payable at periods of less than 3 months. And that was because there were no traditional rent payments. That was the language that Ducker used.
Well, I thought it was simply that Ducker stood for the proposition that those type of payments would qualify, but there was no evidence in that particular case that they had been made.
As far as I understand, the facts in Ducker were virtually the same as in this case. And the court found that given those facts, that there was no traditional agreement with respect to rent, and that the tenant paid utilities payments, that it was inappropriate for a 30-day notice to have been received, and that tenant was entitled to a 90-day notice. I would also add to that by saying that whether Ms. Pierre's argument would prevail on the merits is not the point here today. The point is just whether there is any evidence as required under Tamber v. DeRocher. So the standard for an appeal bond waiver is much lower than the standard would be on appeal. So regardless of what concerns there might be about the merits of the argument, the fact that there is this case that is directly on point constitutes evidence to overcome the notion that her defense is frivolous.
So your best case is Ducker versus Ducker. Is that, are you suggesting that's the best case for the payment?
Well, so there's another case that I can refer to. It's not one that I cited in my brief, but there is an appeals court case called Federal National Mortgage Association v. Duarte. And that case draws a distinction between normal rent payments and other types of payments. Now, the issue in that case was not exactly the same. That case was looking at whether a tenancy at will existed, but Duarte still mirrors Ducker. And again, that's an appeals court case. Duarte still mirrors Ducker by suggesting that traditional rent payments are a separate entity from non-traditional forms of consideration, like the utilities payments in this case, and ought to be regarded differently. And so, again, in this case, Mr. Walker himself has testified that the parties did not have an agreement for traditional rent payments, but Ms. Pierre took responsibility for other payments that neither of them regarded as traditional rent. So regardless of what the housing court may have found in its order on July 28th, the payments that Ms. Pierre was responsible for should not be treated the same as traditional rent payments under the case law.
I'm working remotely and my dog was barking, and I apologize for if you heard some noise. So it's your position that under Ducker, that even if the court here found that payments were made on a monthly basis in lieu of rent, that the judge was incorrect in establishing that was sufficient to allow for a 30-day notice?
Yes, correct. Because the payments that Ms. Pierre was responsible for were not traditional rent payments, which is what would if there were an established period for the payment of traditional rent, that would be a different story. But here there is no traditional rent payment, none that's payable at all, let alone in periods of less than 3 months. So yes, it is our position that the fact that she does not pay traditional rent would mean that a 90-day notice was required.
All right, anything further?
No, I think that should be sufficient, Your Honor.
All right, thank you, Ms. McKinstry. Ms. Greenman.
Thank you. Number one, I do not agree that the court should even look at Duarte. This is a post-foreclosure eviction case that has nothing to do with this case. This case is very clearly, and in a lot of ways, obviously, an attempt to delay the inevitable. My client started the procedure to try to evict his children's mother in I believe 2017 or so, and the judge at that point suggested that unless and until he started paying child support, it really wouldn't be a useful thing for him to try to do anything because he should have clean hands. And so he went and he set himself up with child support orders. He pays his child support. He has wanted this person out of his house and out of his life for a long time. The reason why he purchased the property is irrelevant at this point. There is no non-frivolous defense. I agree in whole with Judge Chaplin, who found that the payment of utilities in 30-day increments, which is would result in her not having lights on if she didn't pay them, would result in her not having heat if she didn't pay them every 30 days. The fact that she has refused at all points to pay anything toward rent does not mean that he would not gladly have collected rent every 30 days if it weren't so difficult in this state to evict people. And this has caused a huge financial burden for him in the upkeep and maintenance of the property, and the division that the defendant has created between himself and his children. And there is no non-frivolous defense as well, because the appeal that my sister refers to is an appeal that she is not representing the defendant on, and I am maybe not quite convinced. Perhaps the defendant has some legal background or has another plan, but as far as I know, the defendant is going to be unrepresented in an appeals court full panel case, for which the only quid pro quo she was given was to pay $182. And Ducker, in that case, the bills were not being paid. It was different. There was a different relationship, different parties.
Well,
And
do you suggest that Ducker stands for the proposition that if they had established the 30-day payments of utilities, that they would have qualified as a rent and allowed?
yes. And I know that the specific lower court judge who made this order has been overturned on her order that 90-day notices were appropriate in the past. So I do believe she is very diligent about this decision and takes her time in making these decisions and considers all of the facts.
Well, hopefully
And
they
there
take their
is
time and
no evidence. And my sister is referring to evidence, but there has been no evidence presented that she is entitled to a 90-day notice.
As I read the judge's order, the judge found that payments were made on a monthly basis of certain utilities.
Yes,
And so it seems as though the difference between the parties here is whether or not those payments constitute sufficient evidence to allow for a 30-day order as compared to a 90-day order.
right, yes, correct.
All right. I mean, I understand the issue, and I will review it. I'll hear you further if you want to be heard, Ms. Greenman.
No, I mean, that's, I think that, again, this is just it appears to be a somewhat insincere, in my view, attempt to just take more advantage of a very technical system that has been hard enough for the plaintiff already.
Well, I understand that goes a little beyond the scope of what
Yes,
I do, but I appreciate your need to represent your client on that. So that nothing further need be said. I'll take this under advisement. Thank you for appearing, and we'll get back to you as soon as possible.
thank you.
Thank you.